So welcome to this training today, part of the program of Innovation Booster Fashion and Lifestyle. Today we will learn more about IP management and legal framework in innovation processes. Let me introduce myself first. I'm Daniele Panato. I'm the Innovation Booster Fashion and Lifestyle Director, and I would like to spend a few words of introduction about the program. So our objective is, first of all, to drive and foster radical innovation in Switzerland. And the program is powered by InnoSwiss, the Swiss innovation agency. Its role is to promote science-based innovation, is to fund also innovation, and to work on technological transfer. And among the different instruments that InnoSwiss offer, there is also the Innovation Booster programs, which are multiple present already in Switzerland. For us as Fashion and Lifestyle, we are at the first year. We are concluding the first year of activities, and there are thematic communities based on single industries or topics. Regarding ourselves, what is the Innovation Booster Fashion and Lifestyle? The Innovation Booster is an instrument that focuses on the very few steps of the innovation funnel, where the ideas are co-created and ideas before implementing them needs to be tested. So the objective for us is to leveraging the beautiful community of fashion and lifestyle industries that we have in Switzerland, but also with international capabilities, and mix the companies and brands with research. So with university and research centers, and try to understand what are the real challenges of the industry, what are the underlying problems that are causing those challenges, and how to tackle those challenges in a new way. So not incremental innovation, but radical innovation, how to use new approaches to create innovation in the sector and come up and co-create ideas. In these terms, the co-creation is made to come up with an idea, and the output is to be tested with this program. And we award up to 10 ideas per year, with a total amount of 27,000 francs per idea to test its potential. We divide our program in different phases. We start with analyzing the market and with industry workshops to work hands-on with representatives of the society, the industry, and also research and associations to understand what are those challenges and those themes to work on in terms of innovation. Then once we located those challenges, we open a call for challenges, meaning that we are then receiving participation, active participation to the program with hypotheses of innovation, how, what we can test and how we can tackle those thematic themes. But then after the application, there is an actual workshop on which we understand the challenges, we deep dive on the challenges, and then we co-create with innovation teams. Then there is a pitching session where a dedicated jury decides upon the ideas to be awarded with the funds, and then starts the real work of the innovation teams with the second phase, we test, implement, and learn. So the innovation teams that I mentioned are composed by at least one research partner and one implementation partner. Research partners can include the university research institutes, but also non-commercial research centers and departmental research institutions. The implementation partners can be national or international startups, small, medium enterprises, big and large corporations. So basically anyone that has a legal entity can participate in the program, and also there are ways for international partners to join an active innovation team. And while the pitch jury in this case, it's a diversified and well-prepared panel of experts in research, business, and society that actually carefully evaluate the ideas presented and decide upon the ones to be awarded with the funds, and is composed by permanent members and temporary participants. And as mentioned, we have the actual composition that will start next year. And it's a composition of professors, researchers, representative of industry associations, university in general, actual brands, fashion brands, but also investors that can have a view hands-on on the industry. What is the output of those funds? So what we use, what the funds can be used for, they are used to test the potentiality of the potential impact of the idea through a proof of concept, therefore a concrete testing, a feasibility study or market assessment. In general, we are going to test, and the innovation teams are going to test 3 areas, each of 3 areas, 1 or more, which are desirability, viability, and feasibility. And we always encourage desirability to understand how and which needs are met with a potential new idea, and if this need is actually met, and if there is actually presence in the market, and if the testing of the idea can be pursued and continue on with the following phases. And also we thank the co-sponsors already on board from the beginning of this year on the program, which are 7 for All Mankind, Alpha Square Invest, Venture and Creation, Group of Florence, Hugo Boss, and Philip Line. So I thank you very much for your attention, and I leave the word to today's speaker that will deep dive on IP management.
Hello, everybody. Quentin Adler. Thank you for the introduction, the general introduction, Daniele. So what we're going to delve into today is, I haven't been as specific to the innovation booster itself, as have been indicated that many of you may not be directly part of it, but if needed, we can discuss that with more depth later on, since I have allocated part of my time, speaking time, to you, so you can also ask questions and we can have an interactive conversation. So let me share my screen. They're working? Sorry, yes? Okay. So legal management of intangible assets in open innovation processes. So I have tried not to overwhelm you with too many contents. So there are a few points on these slides, and I expect you then to converse with me on these if there is anything of interest to you that you would like to go into with more details. So if we look, first of all, I'm Quentin Adler. I'm a lawyer at I'm a partner at the law firm InnoLegal in Fribourg. I'm very active in innovation law generally, also throughout the partnership between state or public entities and private enterprises, but also if you have consortiums or research and development agreements that involve multiple actors, this is the kind of advice you could expect from me, or dispute resolution in that field. This is a bit about me, and I also teach intellectual property at the Haute École Neuchâtel in gestion, and voilà. So you know a little bit more about my background and what I can bring to the table. The key concept regarding intangible assets management when we talk about open innovation. So the type of intangible assets that you're going to face, of course, most of you have probably heard about it, what we call the intellectual property rights, but this is only one part of it, because you could separate this from trade secrets and know-how, which are not necessarily assets, properly speaking. Intellectual property rights are assets that you could collateralize, sell, acquire, and so on, whereas trade secrets As such, they require a certain amount of confidentiality, and know-how is certainly a value, but is not packaged or commoditized, so to speak, as would other intellectual property rights be. So they cannot be disposed of as easily as, for instance, a trademark or a patent. Okay, and then another kind of intangible asset that you could face would be data or databases. Again, something of value in any collaborative process and for enterprises in general. But again, they do not necessarily are protected by intellectual property rights, and they will have specific provisions that would need to be applied to them, especially actually contractual frameworks. If you would like to manage your data or databases, most of the time this is done per agreements with providers or the different actors that are involved in setting up the IT structure or the data process in general, and you can have other types of intangible assets that I'm not going to go into today, but that's for the types of intangible assets that we can mostly see in open innovation processes, and in general, by the way, in business matters. If I look at the special characteristic in open innovations, one very important aspect is the fact that you do have multiple stakeholders. They may come from different backgrounds, so this makes it all more trickier to actually find a common management of the different intangible assets that you will be sharing together, because of a matter of culture also. If you have, let's say, a public education entity collaborating with a large multinational company, of course, they may have different priorities, but also cultures and way of handling things. And this is something that may be a bit tricky. Whereas if you are used to a certain socio-economical milieu background, then well, and you don't necessarily feel the need to adapt on a daily basis. When you enter the field of open innovation, you are facing a variety of factors which require a certain level of adaptation. Okay, and the fact also that you do have multiple stakeholders is something that has to be handled through agreements, because multilateral agreements are more complicated to put into place than just bilateral agreements when you only have two parties that need to negotiate the terms and so on. Okay, so this collaborative framework then is also important when basically as an innovation teams, for instance, you will start to collaborate with others. What are the roles, the responsibilities? We're going to have a short look on that in a minute. And also a specific characteristics in open innovation processes, the fact that you do not need to protect only the closeness, the protection in the classical sense of the intangible assets, but also the way you share them for what you want to share. And sometimes, and of course you do, because it adds advantages also sharing some part of the productions along the line with either third parties or the public at large, so you can benefit from a multiplicity of outputs that comes not only from yourself but from the external third parties, and the scope can be rather large or small depending on whether you want to open it to the point of going open source on certain aspect, or simply having some framework conditions within a defined group of participants. But in any case, you do have to handle both the closeness and the openness, and this is something that needs most of the time to be legally regulated. If you do have any questions so far, do not hesitate to jump into the conversation. I don't know whether the chat is active, perhaps. Okay.
Yes, chat is active, but let's continue for the moment.
Okay. Yes, sure. Now, looking at the types of intellectual property rights. So this is the generic aspects of it, but for those who are not specialized, this is a good reminder. We do have copyright. Copyright, so this is what handles what we call creative works, but also software as such. You don't need the registration to have copyright applying to your intangible assets. So meaning if you write a sketch of something, a scheme, then this will be protected per se as soon as it meets the 3 criteria provided by the law, meaning this is a creative work made by a human as such. You have a creative endeavor. Then second aspect is the fact that it is of, we call it artistic or literally work, but broadly speaking, is what we could call cultural. It has a cultural dimension. It's not merely technical. And the third aspect is the fact that it has a certain level of individuality. The jurisprudence speaks of the unicity, the statistical unicity of the piece of work. And if those 3 elements are met, are gathered, then in this case, you may very well have an asset that is protected by copyright as such, giving you an exclusive right on this. So you have a huge variety of use cases, but in the case of, let's say, teamwork, in an innovation teams, most of the content you're going to produce in writing is going to be protected mostly. The designs, those different elements may be protected by copyrights, and this is something again that you have to know who then owns those items, those assets, and then who can then afterwards use them later on. So this is something that, if not properly regulated as part of a contract, mostly within a team, then it can create some legal uncertainties or conflicts even later on, if not handled properly at the right time. And honestly, the right time is usually prior to starting your collaborative endeavor within the team.
And
So
Quentin, let me intervene on the copyright. I heard that
Sure.
you mentioned the cultural aspect. So how in software the cultural aspect is covered, or one of the 3 criteria? So how is considered also by law this aspect? Because I think in innovation processing, in technology, in our case, many times also the one of the most sensible production are software based. So if you can shed some light on that, would be great.
You mean on the software aspect specifically?
Yes, like if a party writes lines of code or a little
Absolutely.
development uses also, if you have examples now, which is very popular, and it will be much more, how AI intervenes in the copyright, how it
Absolutely.
limits it, etc.
Okay. So to make it clear on the matter of software, what you have to, because I do believe every one of you understands copyright at some, let's say, gut level, okay? So you know very well that if a book is being written and then you add up your name, it has those criteria, meaning it's a work of literature, and this is an individual character, and this is a creation of a human. It has used creative endeavors to reach the result, then this is protected by law as such. And the protection is actually almost global in the world, because you do have the Convention of Berne, which makes the basic requirements and standards of protection harmonized throughout the globe. In most jurisdictions, your piece of work would be protected. The same day then is true for software. Software, you type your code, it has a level of individuality as such. It is per se protected as soon as you can identify more or less that it has been the result of a creative human endeavor. Now, Daniele, what you pointed out is very interesting regarding AI, because we are at a turning point right now. Because if you look at the 3 criteria that I mentioned, the fact that it is human creative endeavor, the second, okay, fair enough, artistic and literary work, this is okay. Cultural pieces, we can. This is not a matter of big discussion. But then also the third aspect, the individuality criteria, is problematic from the point of view of having copyrighted materials being produced by the AI. Because the first aspect, this is something that is being discussed, let's put it this way, because some argue that the fact that you could be very creative in the way you prompt, the way you direct the machine in getting certain result could fulfill the first criteria. This is something that is being discussed, but still a bit controversial as such. I'm not very convinced by this argumentation, because the problem is that at the end of the day, the machine is handling so many things, so many parts of the creative process that I barely see how the human control over it can justify a certain level of protection. So this is for the first criteria. But the third criteria also is very problematic, actually, and in my opinion, not fulfilled with Gen AI, because Gen AI as such reaches for the highest probability in the generations of its content. So this is the exact opposite of the requirement from the jurisprudence, from the statistic unicity, the fact that this is something that is unique, that statistically should not occur very often. And the fact that actually Gen AI does the exact opposite, in my opinion, would go against the fact that the outputs created by the generative AI will be copyrighted. So that's for copyright in the field of software, and also considering the new digital tools at our disposal. But consider that this is a very broad, not field of protection, but I will say the activities you have as part of an innovation process very often are going to generate items that will be protected by copyright, as soon as, of course, this is done by humans within this collaborative process, given the three criteria I've set for you. Now, another element to consider is our trademarks, which is very important, of course, in the fashion industry as such. So this is something that has to be discussed also, in my opinion, as soon as possible, especially if you do have a form of joint venture in which you want perhaps to create new product together. So you have to make sure that if you want to use new trademarks, you have the fair rules of use of this trademark afterwards. And I have to also, because trademark as such, what are they? They are signs that are distinctive between products and services. Okay, this is what it is. And those signs, distinctive signs as such, they can take many shapes. So of course, you know the text as such, like Google as a word, but you also know Google, for instance, as a logo. And you know Google as both the logo and the text. Okay, so those are the conventional categories of trademark. But if you would like to innovate on trademark as such, and I'm saying even like doing legal innovation within fashion, you could also imagine like having an olfactive trademark, which is something that has not been done yet. Okay, but you do have novelty that are already existent, and that are already existent and which are unconventional. For instance, you do have three-dimensional trademarks. You do have also position trademarks. So meaning depending on where the trademark is, and the fact that, for instance, I don't know, it's on a cape, the fact that you have a certain color at a certain point, and then when a consumer sees that color at this position on this items, you will have a direct recognition. Oh, this is this brand. This could also be a valid form of trademark that could be registered. You do have musical trademarks also. You know, the da 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 da. You make as soon as you make an identification to a certain product or service of company, then it might be possible that this is actually a registered trademark. So this is something to consider while you innovating, because as you are creating things which perhaps have a certain value as distinctive signs in the market, perhaps you should make sure to first identify them correctly and handle the fact that who can use what, the same as with copyrighted material, but also be careful, trademarks need to be registered. And so you need to follow a registration process. And again, say who is paying for that, who's then at the end is declared the owner, and who can use the trademarks once they've been validly registered. Those are also elements that I think are more relevant within the field of fashion and industry, perhaps than in other fields of innovation. Although, as soon as you do have a common project, most of the time you do have specific designation or names that perhaps you would like to protect of a longer period of time, because those, for instance, the project itself is being using a specific name that serves as a distinctive sign. Okay, this is for trademarks as such. Then, of course, you do have patents. I'm not so sure how relevant they are within the innovation booster, especially fashion and lifestyle, considering the fact that the time frame you have and also the goal to reach proof of concept is not the most adequate, if you will, to reach the stage of a patent registration. But who knows, perhaps this is of relevance to you still nonetheless. Now, what you have to understand about patents, this is really the fact of seeking technical solutions to technical problems. Okay, this is what is being looked at. Again, this must be a human endeavor. This time an innovative one, and you have certain criteria. I'm not going to spend too much time on these, but basically, but actually I will, because Daniele, you mentioned the use of AI and what it changes in the landscape, and in my opinion, it changes many things. Because so I said, human endeavor, a solution to a technical problem. Okay, fair enough. It has to be considered novel. Okay, the novelty aspect and the fact that this is not obvious, considering the technical state or the state of science at the specific point. Okay, novel is the fact that it has not been disclosed before. So translation, any patent had prior to be a trade secret. Okay, that's one requirement. But then the fact that it has not to be obvious from the standpoint of the state of the art, if you will, this is something that is going to get trickier and trickier with the advent of artificial intelligence. Because from the jurisprudence point of view, what you do when you want to assess the non-obviousness based on the state of the art is that you put yourself in the shoes of a man or a woman, an expert, basically, in the field. You're giving the usual tools that person uses within its field of expertise, either her field of expertise. And based on that, if you give him like some time with the different elements in front of that person shouldn't be able to reach the technical solution that has been found. Okay? But the problem is, as soon as those tools, those usual tools, imply artificial intelligence, and so reaches such a high level, actually rise the standards, the ceiling, if you will, of what the state of the art is. In this case, it means you will have less and less inventions that are going to fall into the scope of non-obviousness from the standpoint of the technique of the state of the art. Do I make myself clear on that? Because this is something that may completely change the landscape in the coming years.
Yes, you could.
Yeah, because basically
you can perhaps do a concrete example of this.
I'm gonna do a concrete example of this, but basically, or just expand on my explanation. So patent, they require a registration for 20 years. You have a full protection, and so you have the absolute rights to dispose of the invention, also in its materialized form. So once it's produced, not just the scheme, not just the abstract concept, but also the materialized invention. Anyway, so I'm saying 20 years of protection. After those 20 years of protection, it falls within the public domain. To put things into an historical perspective, the reason why we do have a patent regime in the first place is at the beginning of the Industrial Revolution, what the state wanted to avoid is to have all economic actors creating many secrets, to protect them and avoid the fact to share the technical knowledge to the rest of the world, because otherwise they will lose their competitive advantages. So the deal was, okay, we really want to have some technical progress in society overall and stimulate that. So what we do is, if you accept to publish it openly, okay, we give you an exclusive rights on that for a duration of 20 years. But after that, it's available for everyone, okay? So that was the historical deal. Now, think about it. Think how many now inventions are in the public domain and so are free to be used as pieces of information and knowledge for the artificial intelligence. So then it can gather them together and create new invention based on prior art, if you will, and to a capacity that humans could not do based on the limitation of our brains. Okay, so if you consider that, the numbers of possible inventions that now belong to the state of the art based on the usual tools that an expert will use have increased massively, okay? Reaching the point that they should no longer be considered, or rather they should be considered, those new inventions, obvious from the perspective of the state of the art, okay? So that's to say we may face a massive change in the landscape with the arrival of and the massification of artificial intelligence, okay? But we are not there yet for the moment still. And I guess also what you have to take into consideration is the criteria I'm criticizing, the fact that the non-obviousness is going to be a criteria that probably is going to be very difficult to reach. This is still reviewed at the time being by humans within the EP, so the Federal Institute of the Intellectual Property. And for the time being, they won't make the difference between what has been generated by AI and what has been generated by humans. But at some point, I guess this is going to change. So you can, if I may say, still play the trick, even if it's being generated, even if you found out inventions through AI-generated processes, take the slot because you have a few years during which you can still patent it. But I guess in the near future, it will no longer be the case. Anyway, so patents, I think we've discussed that. If there are any further questions on this, we can discuss this any further if necessary. So I'm saying, yeah, 20 years need to be registered and needs to be kept secret also prior to this, which leads us to the last category, which is not properly speaking, in my opinion at least, it depends on the qualifications, but does not necessarily belong to intellectual property rights, but those are trade secrets. So trade secrets, those are requirements, of course, to have patents if the secret was concerning a technical solution to a technical problem. But more broadly, trade secrets is another aspect you have to take into consideration in any collaborative process, that since of course they do have a certain value, competitive advantages possibly, although you should also assess whether this is the case or not. Trade secrets as such, they are protected mostly by criminal law, broadly speaking, either to the Unfair Competition Act or the criminal code as such. You have three criteria to consider that you effectively have a trade secret protected by law. The first being there's a secret, meaning it has not been disclosed, it has not been publicized. Second element is the fact that the holder of the secret has the will to maintain the secret. Okay, because you could have something which is, we do all have things that have not been disclosed to the rest of the world, but we do not really care whether they're being shared or not at some point. Okay, so this has to be manifest that the holder of that confidential information, let's call it this way, wants to keep it secret. And the third critical element to have a trade secret that is protected by law, generally speaking, is the objective interest of maintaining the secret from an economical point of view. Basically, you have to consider whether if I would share this information to someone else, do I risk creating, let's say, competitive distortion, or to lose an advantageous, or to give a competitor an advantage? It is an abstract thinking. Of course, you do not necessarily need to specifically establish that, but the secret as such has to be of objective interest. Has to be if you want, the fact that it is being kept secret has to be objectively necessary from an economical point of view. So I'll give you an example. For instance, let's say you're a restaurant and you have a very good recipe of pasta, okay, but are based on a classical formula from Italia, okay. Uh, in this case, the fact that you want, perhaps you've stored that the recipe on your internal servers, and you've let your employees sign some non-disclosure agreement on this. Well, then you will have to assess whether the fact that you're basically using a random classical recipe is worth protecting as an objective economical interest. And most likely in my example, the idea is to say rather no, because this is something that is known for anyone. And if someone will know the recipe that you use, which is basically a classical one, then it will make no difference. In this case, this would not be considered protected trade secret. But to change those facts, if I take another statement of facts, and for instance, we say you are a restaurant and you do have a process at which, at a specific timing, with a specific dosage, you're going to add up this ingredient, and then after that, you're going to keep them warm for 3 minutes so that the end consumers at the end, once the food reaches the mouth, this is the perfect temperature, and you monitor all that, and you have a full processes within your company that monitor how food is made and brought to the clients. And in this case, we could consider that if those information will be leaked, this will be a competitive disadvantage for your company or an advantage for another one. In short, it's going to create a competitive distortion. And so you will have the third criteria of trade secret being met. So those are for trade secrets as final categories of intellectual property rights, although this is not as such an asset that is as tradable and collateralizable and so on, financeable if you want. This is not such a perfect financial instruments if you compare it to the rest of the intellectual property rights that I've mentioned. Copyrights, copyrighted material, trademarks, patents. This is something that can be easily sold, licensed, and so on. Trademarks, trade secrets, less so. Okay. Well, then you do have the different legislation that apply, that are relevant to what I just discussed here. We're not going to go into that. One very important, one key aspect when dealing with IP rights within a team is you have to check first the background IP. So meaning, so you do have multiple partners that are going to join and do a project together. Okay, perhaps some of them are going to use part of their intellectual property rights to collaborate in this project. So you have to make sure to identify what comes. So background IP is what comprise, what is the existing IP rights that they're going to bring to the table, and of course, how can the and to what conditions can the other use those rights? Okay, and this is going to be important during the collaboration, but also afterwards, because then when we speak about foreground IP rights in this case, so the results themselves may also be subject to intellectual property rights. And this is important for you to be able to use them, especially if you've been collaborating to produce them, okay? But sometimes they may depend on using background IP rights from other parties. So in this case, this is something that has to be discussed within the team so that you know that you can access background IP rights from other partners to the extent necessary to use the foreground IP rights, respectively, the results of your collaboration. Daniele, am I making myself clear? Yeah, good. So meaning foreground IP rights, this is also about allocation. Who owns what and or who can use what, okay? Something that have to be discussed. And side ground IP, well, it depends on the type of project that is less critical, but the problem is most of, I'm not going to spend too much time on it, but basically just background IP is really what's come prior to the project, and side ground IP is what you're developing in parallel of the project. And this has to be clarified because sometimes you may be collaborating with the same actors on the one side and on the other. And so this sometimes you need also to monitor what is being developed next to the project, okay? But I'm not going to spend too much time on it. Just to say you have those three categories that has to be taken care of as soon as you collaborate within an innovation team.
And a question, sorry, Quentin, just to clarify on the background IP, from what we understand, it's important to define the limits and the perimeter on which a party already comes. So it's the packages, it's the baggage of IP that comes into a potential innovation team, while the foreground IP, if you can also clarify what are the main aspects to agree upon among an innovation team. So when a new IP is created, the way it could be used, how many dimension is important to expand this, because I think it's quite abstract, of course, at the beginning of an innovation journey. And it's important also to understand the duration of this process. Is it forever? It's needs to be regulated. It needs to be regulated also among the different parties and companies or groups. If a company is part of a group, if there is any implication, if it's I don't know, form of company, kind of company, global or local. So these kind of dimensions.
So this is why it's difficult to just be very generic on those topics, and this is why I've just like marked a few points, and then it's open to discussion. But what you write, I will say you have two ways of handling it. This is at least my school of thought is this, is to say either you want to make it the complicated way or you want to make it the simple way, okay? The complicated way is you have to deal with each and every individuals who can use what for what duration, very well identify the different items and so on, okay? The complication of that, and then what you can see sometimes is also, sometimes you have a limitations, like one of the partners can use it like in the field of, let's say, watchmaking, and the other one can say in spacecraft, okay? And the problem with that is it needs, so first, a lot of paperwork and a lot of micromanagement afterwards, okay? And at the end of the day, if someone breaks the rule, there must be consequences. So this isn't like we've set a complex legal framework and it's going to run by itself. No, then you also have to enforce it. So this can be tricky, complicated, and subject to interpretation. So the second way, the simple way, and this is the one I've developed, and you do have, Daniele, the templates that you can make available to your teams, is basically to open source the results. So you create free licenses, and this content is going to be available to everybody under certain conditions. You can decide then, if I took free licenses, you had two variations. The first one being basically, well, you make it available, anyone can use it, and you do not expect more than that. And the second variation is say anyone can use it, but if someone's make any modification or improvement to this invention, then it also has to make this modification, improvement, to place it under the same license as the primary license, to make it available to everyone. So you have a snowball effect in this case, what we call the copyleft, okay? So basically I'm saying, let's try to say I've developed a software within the teamwork, okay? As part of the teamwork, at the end of the day, I'm saying, okay, I'm going to place it on the GPL, General Public License, for instance. And it means, okay, anyone can use it, but if someone's modifies it, improves it, this modification improvement also has to be released publicly, so I can use it even if I haven't been the owner of it. Okay, so that's a good trick actually to have a snowball innovation, and this is very useful to create actually for anything that is that serves as groundwork, as something that is not necessarily like the key element that makes the specificity of your project and so on, but that you're going to use anyway, and you don't want to spend too much time on R&D and even promotion of those technological items, or not necessarily technological, because it's also documentation and so on. Well, this is a very good way of handling it. So it's very easy to use, and you can also have sometimes benefits, side benefits, if you will, by having others using it and then improving it for you. So this is those are the two aspects. Either we want to make the closed way, and you have to make complex structures, and sometimes you have to, or this is what it is in your interest, or you have the open source way, and then in the open source way you either have the like permissive license or the copyleft licenses. Copyleft licenses being these mechanisms of creating a snowball effect and obliging that any improvement on what you've released freely is actually made available to you at the end also. Okay?
Clear. Thank you.
And so if we look at the legal framework, so you do have different instruments that you can use to basically regulate your team, what we call the team rules. So how you're going to work as a team. So basically non-disclosure agreements, this is something that is rather useful. Actually, also it helps with trade secrets, because it assumes more or less the two first criteria are met. So meaning the fact that this is something that is meant to be kept secret, and you have the will to maintain the secrecy on that. So this is not this is rather useful to have non-disclosure agreements, but be careful with that, because what I really disapprove of, practically speaking, is to be too broad or too specific, actually. So you really have to define precisely what is the object of this non-disclosure agreement. It should not be just everything that is being discussed between us. Okay, otherwise it's going to lose its effectiveness, because you discuss many things with many people within a team. Okay, and you cannot expect them to handle everything as a secret. So you have to find a wording which is sufficiently generic, but also sufficiently specific, to find a balance to define exactly what you want to maintain as a secret. Okay, because if it's too precise and you say this is like item AB, and then they say, but then it's not item AA. Sorry, it was only AB. Okay, so that's but on the other side, if it's every discussion that we have within a thing, then it makes no sense either, because of course everything that is going to be discussed is not going to be treated as a secret. Okay, then of course you have the team agreements themselves. So this is you can insert the non-disclosure clauses within the team agreement. Okay, the team project agreement, if you will. So this is how you collaborate with the other, the assignment of intellectual property rights at the end. For instance, this is everything that's going to actually regulate those aspects regarding also background IP, foreground IP, and so on. Okay, we do have provide a template of that if you want to follow the open source route, that basically also helps you with the other collaborative aspects that are not IP related. And then of course you have IP assignment agreements. If your only concern is to handle the IP assignment, you can also just have a separate agreement only on that, and you're gonna spare spending too much time on discussing the roles or other considerations which are more performative, if you will, as part of the project, but perhaps this is not what is of interest to you. Okay. So I make a notice of different key elements to address. So IP ownership, who owns what, because then also you have to understand that this might be different of who can use what. So the owner, most of the time, can use its own intangible assets, but this is one aspect that is slightly different than who then can use it. Okay, so this is a clarification that has to be made. The roles within the team, who can use what, confidentiality obligations, what exactly they are, and so on, and the publication rights also. So who, if you disclose certain information, for instance, if you want to publish a part of your results. You also have to regulate these aspects, saying who has the responsibility, for instance, to open a repository on GitHub, okay, and who has the rights then on this repository and give access to whom, okay. This kind of thing on publication is also something that is to be concerned of. If you have a scientific publication, the same applies. Also, you have those are some aspects that you have to consider and, in my opinion, regulate within your team rules. Okay. And just in terms of data management and protections, take into consideration also that you always have the data protection law that is applicable. So this is something that has to be handled specifically, but also non-personal data, which sometimes do not, as I explained, do not necessarily fall under the scope of intellectual property laws. This is something that you have to consider if you have, like, for instance, metrics. I don't know, let's say logistical metrics on you've made certain. So in the 6-month project, I don't think you're gonna be confronted to much of these things, but you never know. Once you do have studies on certain aspects, you may collect data, and you also have to handle what you do with these data. Okay, and those are technical data which do not belong to either of the categories I've mentioned earlier. So this is something also that you may be willing to think about. Well, yeah, and the rest. Those are some general consideration. Perhaps as the last touch, so I would like to go into what could be considered best practices for implementing the different things that we discussed. So having a clear IP strategy, I think this is something that is required for innovation teams in general. So you understand now the different aspects of, for instance, background IP rights, foreground IP rights is something that you should really handle upfront and not wait until it's too late. Because once you do have interests that manifest clearly, it's more difficult to handle those aspects afterwards. Yeah, documentation is also very important. Actually, tracking who is contributing to what, if possible, and having it, if possible, having a common folder, a share folder in which you can see. This is why also GitHub is a great tool, or Git in general, because you can see also the tracking of the modifications. Because this is one aspect that I haven't handled, but the fact is, once you collaborate among, and so meaning you have multiple people working on the same piece of work, then you may have also shared rights by default. If you haven't made special provision on that, and then you have to know then who has participated basically to the creation, and this is something you have to monitor. And tracking systems such as Git are very practical for that matter. Record decisions. So of course, this is something, everything that you decide that is of importance that should be documented as much as possible. And yeah, regular reviews is the fact that also just you have to update as you progress within your project. You have to check whether what you've agreed upon in the first place is still applicable, of course, midterm or later on, and also review the rules of the game if they need to change during the project itself, because by definition, innovation is a disruptive process, so perhaps it's going to disturb also your collaboration. Okay. Voilà, and I've let some floor for but I see that there aren't many people there, but if any of you wants to share some information with us about the fact that perhaps what is your position, are you managing intangible assets or not? Perhaps you, Daniel, if you will be the one then to ask
Yes,
question.
no, thank you very much, Quentin, first of all, for the real clear overview and insightful on this aspect, which is sometimes overseen to get directly hands-on on a project. But I think it's key to set the rules at first before starting the project for the benefit of its future. And that's what we do in Innovation Booster. We give the first spark of possibly a future bright future to radical innovative ideas. So I would like these few last minutes to use it with these questions. And I think since this session is recorded and will be available to the whole innovation community of Innovation Booster in general. So leave these questions open for anyone who watches later on this session. And if you can conclude leaving your contacts, and of course, as it can be reached via email, on info@ibfashionandlifestyle.ch. But if you can also leave your contacts, would be great. Yes. So I think it could be a value to reach out to Quentin, which is well prepared on the matter and can support you on your innovation journey. So I will conclude the session here.
Just
So
one
thank you
last
again.
thing, Daniele.
Absolutely.
Okay, just one last thing. I showed you this slide because I wasn't sure whether you wanted to go into the specific of the innovation boosters, but that's just to give a clear vision also for the different actors actually that might be concerned. So what we discussed, you do have the application. So there's different layers. Here we were mostly speaking of the team rules. Speaking when you are part of an innovation team is what you have to be careful about. Okay, of course, this directly implies applying correctly Swiss law. Okay, but the fact is, Daniele also has a framework set into place, which are the program rules. So this is him as the operator, if you will. He's going to create a framework that is supposed to encourage as much as possible the innovation, collaboration, and so on. And so you do also have those program rules that have been set into place and that have developed actually. And I think this can also be helpful for you to know that they do exist and they help you structure and bring a certain amount of legal certainty once you participate within the program. Okay. So this was just to say that we're talking here about innovation teams, but in terms of legal innovation for financing open innovation or setting into place innovation programs, you'd have different layers, and we've developed at least two of them quite intensively. So this is not my services will not only aim at innovation teams if they are interested into that, but also for operators, for the one that would like to set up program rules as such. Also outside of the innovation boosters, this is something that I'm capable of doing and that we've done very well. And actually, InnoSuisse have asked us, meaning my firm, InnoLegal, to support them and publish that. So we have a good track record also on those aspects regarding financing and structuring the program of open innovations themselves. Yeah.
Great.
And also,
yes,
you see where we are, what we're talking about exactly. Yeah.
Yes, absolutely. Thank you for the clarification. And it's important to see the different layers and how the above layers are overarching the below ones and they are not need to be in conflict with. So thank you again, Quentin, and see you next year, perhaps.
See you next year.
Thank you so
Take care,
much.
Daniele.
Thank you. Bye-bye.
Bye-bye.
Thank you.